17 Liberty 7, there are no words to come close to explaining how absurd it is that we have to walk on eggshells and pre-plan how to save our own lives from the scum of the earth with the least amount of legal ramifications. Yes.
I agree.
We are the Armed Attorneys. Back by popular demand, we are discussing again whether you should be shooting to wound or shooting to kill. And there are lots of different considerations to this. I mean, in addition to your basic safety considerations, we're going to talk about criminal law versus civil law. We're going to talk about whether or not you have a duty to render aid. And finally, we're going to be answering some of your questions from our previous video. But before we get started, share your support for the Second Amendment by hitting the like button.
And this is a very fun topic, and there's a lot of different paths we can go down, so make sure to stick around. But I think we have to start the discussion by talking about different levels of force that our law contemplates. So I'll say most states have 2 levels of force. Think punch, grab, tackle, restrain, maybe pepper spray, something that would hurt, leave a mark, but wouldn't cause serious bodily injury or death. Deadly force, that's force that's intended or causes serious bodily injury or death. Serious bodily injury would be like protracted loss of a limb, permanent disfigurement, loss of an organ, death. We all know what that is. And some states have a third intermediate standard because that's not clear enough, I guess. But we look at, all right, we have different levels of force. We're always seeing people on the news, or maybe folks who don't understand how firearms work say, he should have shot him in the legs.
Mm-hmm. And unfortunately, what does that qualify as if you are shooting to wound, not shooting to kill? Richard, is that force or deadly force?
That's going to be deadly force.
So it doesn't help you in that regard, right?
No.
So in the criminal world, I mean, that's as criminal practitioners, we will tell you all day long that if you are going to shoot someone, make it count.
Sure. Well, I mean, the law, and this is the way that I imagine and talk to clients about it. Imagine it's one of these 2 buckets. Your use of force has to fit into one of the 2 buckets, or if you're in one of those weird states, you got your third middle bucket, right? But it's going to get filed into one of those categories. So anytime you discharge a firearm, it's going to fall in that use of deadly force bucket.
Yes. Now, I will say, looking at sort of the other side of things, and even as a criminal lawyer a little bit, you remember that one time I got to argue, well, he just shot him in the legs, and it was like actually great because it seemed really, really good. Like, oh, he didn't really want to hurt him. Now, I think that he probably just missed. But it was not a bad argument to make in court. But I will tell you from other lawyers' perspectives, i.e., my husband, who practices literally the other side of this, who does like wrongful death, and he's dealing with getting the money because you shot someone or because someone shot you. He will tell you all day long, shoot him in the legs, because scummy, horrible plaintiffs' lawyers, if any of you are watching,
those are the people when you slip and fall at Walmart, run up to you and give you a card. The ambulance chasers.
So they will take a dead body case 7 days a week, twice on Sunday. There are so many dollar signs attached to a dead body. However, you just get injured because you attacked somebody. I mean, there's still a scummy plaintiff's lawyer who will take that case, probably, but fewer and farther between, and they're probably worse lawyers and not going to get a good outcome.
Yeah, but on the other end of the spectrum, we just had a case where the person tried to sue for personal injury over someone brandishing a firearm in self-defense. And those plaintiffs' lawyers eventually, once everything came down to it, said, okay, they dismissed their own case. It's called a DWOP, dismissed without prosecution, for want of prosecution. So, I mean, you see, they'll take a case like that, claiming personal injury. Can you only imagine what they do on the other end of the spectrum? But I think to answer that ultimate question, should you shoot to wound or kill? I think there's option 3, door number C, shoot to stop the threat.
Shoot to stop the threat.
Yeah.
Which is exactly what you should be saying in any official statement as well. Do my Lucille Bluth.
Don't do that.
No, because regardless, right? I mean, you can be like, this guy attacked me, broke into my home. I shot him to kill him as dead as I could possibly kill him. I still want you to say, I wasn't trying to kill him. I was trying to stop the threat. So it's always the right answer.
But don't do the wink. Don't do that. actually had this sidebar, had a officer. I was a prosecutor at the time. I was directing his testimony, so I was asking him questions, fully cooperating, did everything he was supposed to do. The defense attorney asked him a simple question, and the officer immediately went, "I don't recall." Looked at me. I was like, "What's up?" Like, don't do that. So
I
people are
actually,
so.
without you telling me, I think I know what police agency he came from.
But all right.
Good old county we worked in.
But to go on to so I think that answers the question. So it's going to be counted as a use of deadly force. Stop the threat, obviously. Most folks train shoot center mass, for that very reason. It's not practical otherwise. I mean, folks have trouble hitting the center of a target,
Right.
Especially in one of these dynamic situations. Can you imagine aiming for something so small? But I think the next question that came up a lot that we have to talk about is, do you have a duty to render aid should you find yourself in one of these scenarios? Let's say you aim center mass, you hit the leg, person's still alive. Are you legally required to help that person?
So, and that sort of we break out as well, right? Because generally speaking, and now I know people are going to chime in and say, oh, but I'm this or I'm that. And yes, there are some people who do have a duty under their licensure to go render aid, right? You are a EMT, things of that
But even
nature.
there, the scene has to be safe.
Right. So, yes, your particular circumstance, if you are one of those very special people, may vary, but generally out in the world, if you're just Richard or I, you do not have a legal duty. You're not going to get arrested or punished for not rendering aid. However, this is another place where the criminal and the civil lawyers may diverge a little bit, because the civil lawyers, again, who the civil guys probably want you to shoot the legs because you're less likely to get sued and less likely to pay out a bunch of money for it, they will tell you you have a legal duty to mitigate your damages.
Yeah.
Right? Meaning, like, keep the guy you shot as healthy as humanly possible because you're supposed to keep that money down. It's a crazy thought in a self-defense scenario, but still applicable. So would say the civil guys. Now, that's not us, but
Is calling 911 enough mitigation?
I think it's good mitigation.
I think it's good mitigation.
Yeah.
Well, especially as we mentioned earlier, while there may be no legal duty imposed, maybe it's the right moral thing to do. Don't come to us looking for moral guidance. But truthfully, you never, and I don't think anybody will be able to tell that a scene is safe until they're sitting comfortably back in their armchair at their house after the event has passed. And so obviously we don't want folks to endanger themselves.
That is absolutely right. I mean, more often than not, I mean, I don't think, other than oddly, the guy I had shoot the legs that I was talking about earlier, I think he is the only client I have ever had who has rendered aid. And he took off his belt and he used it as a tourniquet.
How did it go?
Well, I mean,
Was he charged with a crime first off?
He was charged with a crime, but charges were fully dismissed.
Okay, civil, what happened?
He did not get sued.
Wow.
So,
Statute of limitations, have they passed?
very much gonzo, years and years and years
Congratulations.
ago. Woo! But oddly, same guy. But he is, I think, my only client I have ever had render aid after having used his firearm in self-defense. So it doesn't happen very often. I can tell you, as a criminal practitioner, I am very comfortable with you not rendering aid, so long as you can say, look, this is the guy who just attacked me. He's dangerous. I was scared enough of him that I had to shoot him. I really don't feel like I can safely go render aid. And I think that's fair.
Yeah, that is a completely fair explanation. Now, we got a bunch of questions from folks regarding this topic. I wanted to go through some of these to answer some of the frequently asked questions or questions that folks wanted the answers to. So let's just jump right into it. The first one that we had was from jhater64. I was told by an attorney back in 1987, if you find that you have to shoot someone, remember one story is better than two.
That is sometimes true. Criminal lawyers will tell you that is sometimes true. I certainly have had clients where I'm really glad the other guy wasn't alive to tell his side of it. However, again, I mean, I think our official advice would be to stop the threat.
Yeah,
correct?
stop the threat. I think is where we landed on that one. And, in the age of everything is, I don't know that everything was being video recorded in 1986. It's pretty rare to have no witnesses.
Right. And not just that, but I think the forensic and crime scene reconstruction capabilities were lesser in the 80s as well. And so your story was more heavily relied upon, and one story more persuasive than two. It's a little bit of a
Yeah.
different scenario
And
now.
ballistics have come a long way. I mean, they can totally tell when you say one story's better than two, flick your cigarette out, and shoot them execution style on the ground. They can totally figure that out now.
Yeah. Yeah, the echo of the statement. All right, so we have at Ted Cheeseman 2914. Is it okay to use beanbag rounds from a shotgun that is a non-lethal round? I love this.
Yeah.
I love this question. I mean, is it okay? Sure, if tactically you keep yourself safe that way. Is it deadly force or is it force? And that is the more interesting question, Ted Cheeseman.
Yeah. And it's honestly, it is going to depend.
Yeah, totally
If
depends.
you're in the state of New Jersey, a slingshot's a firearm. So, it's just going to depend. But even here in the state of Texas, if the beanbag round is being propelled by an explosive, it's a firearm, even if it's a beanbag round. In some states, they're going to say that that is a less than lethal. That is not going to constitute a use of a firearm. So it's really, really going to depend. I will say in the one.
It's going to be up to a jury here in Texas.
Yeah, exactly right.
Yeah.
And I would say even, I'll just keep with Texas because this is what we know, but let's say it was air propelled. I can confidently say air propelled beanbag round, not a use of a deadly weapon in Texas. Or not a use of a firearm. Sorry.
Correct. But is it a use of deadly force if it actually causes some sort of serious bodily injury?
Yeah, let's say they lose an eye.
They lose an eye, then it is a use of deadly force.
Yep.
Absolutely. So it is very squishy, but it's an interesting question, and it's definitely something that is going to be considered heavily by the justice system.
Yeah, and I'd say the self-defense principle that it falls back on is using the least amount of force necessary to stop the threat. That is going to be, objectively, it's a lesser use of force. And so if it stops the threat, keeps you safe, and the other person doesn't die, it sounds like mission accomplished.
Oh, yeah.
All right, next question I have is Coyote Blue 9733 says, when I was in EMT school, they taught us not to enter the scene until the scene is secure. Several places, protocols, it's EMTs don't enter the scene until the cops say it is safe. Why would you have any duty to render aid? And why would it be any different? I think he makes a very good point.
That's a very good point. Correct.
Yeah, I would say, and this is what it looks like from your attorney cross-examining the police. Let's say the police try to, or prosecutors try to insinuate, hey, look, you should have saved this guy's life, or you should have done something different.
So unrepentant, merciless, cold-blooded killer that you are.
Yes, we would be able to cross-examine the police. They open the door to that. What is the protocol in your city? Do EMTs go in and until you've secured the scene? Would you hold an EMT to the same standard? If the answer is no, it's very unfair, and it would be misleading to the jury to impose that duty on the self-defender. I think he makes a fantastic point. Not so much a question. I just think it was an interesting perspective.
Yes. And this is the, again, not a question, but just, I like it. At 17 Liberty 7, there are no words to come close to explaining how absurd it is that we have to walk on eggshells and pre-plan how to save our own lives from the scum of the earth with the least amount of legal ramifications. Yes.
I agree.
Agreed.
No, it's a double standard. Self-defenders, we have everything to lose. We have houses, we have cars, we have jobs, we have families.
We're held to the highest standard.
Scumbags,
held to no standard.
Well, it's because they got nothing to lose.
And they got nothing to lose. So, should you shoot to wound or shoot to kill?
Shoot to stop the threat.
Depends on what lawyer you're asking.
Sure.
Shoot to stop the threat. Bear in mind that your money and your liberty might have different answers.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And comment for us below, would you ever aim at the legs? Until next time, we're the Arms Attorneys.